Greetings, my dear learners. I am Dr. Sonal Agrawal and welcome to my channel Learning with Fun. This is a short presentation on essentials of a valid contract that you may go through for a quick revision before the exam, as it is a rather lengthy topic under the Indian Contract Act. Apart from that, Indian Contract Act is a part of some of the most basic courses and some of the most important courses like BCom, CA, CS, and hence this presentation would be useful for all these students. Moving on to the first slide, introduction to the concept. So the law relating to contracts and the essentials of a valid contract, they are contained in the Indian Contract Act of 1872. So as you can see, it is a rather old act, but the provisions are relevant even today after the amendments that are made from time to time. This act is the foundation of mercantile law or business law, as we may call it. The object of this act, like every act has an objective, it has a preamble, and herein the object is to ensure that whatever a man has been promised, it shall be performed. Moving on to the definition of contract, it is defined in a single sentence under section 2 subsection H of the Indian Contract Act, and it says that an agreement enforceable by law is a contract. So you might see that the definition is rather simple, but the concept is not so. The definition can be put down in the form of a chart over here, and these kind of diagrams, these kind of charts and figures, they can be used in the exam. And here, as you can see, that contract is the amalgamation of two essential elements, that is agreement and enforceability by law. If any of these elements were to go missing, then we would not have a valid contract in existence. Moving down to the essential elements, the first element, agreement, is nothing but offer plus acceptance. Now, offer and acceptance are dealt with in detail in the later chapters, and herein we will be discussing these just by passing by. The second essential element is legal obligation or enforceability by law, which requires that the agreement must be capable of being enforced in a court of law. Hence, in order to have a valid contract, we need to have an agreement that is enforceable by law. Here again you can see that the first circle on the left, it shows agreement, and the circle on the right shows legal obligation, and the place where these circles combine, the common area between these two circles is what is contract. So contract equals to agreement plus enforceability before law. This is the foundation of the act. Now let us look at the essential elements of a valid contract. There are in all 10 essential elements for a contract to be valid or enforceable. Some of the points are rather lengthy and they contain a lot of provisos and lot of exceptions, whereas some of the points are very much in short and simple to understand. Now we will go through each of these in brief. Offer and acceptance, like I have mentioned, that these are topics that need to be discussed out separately, and this is the first condition. There must be a lawful offer and a lawful acceptance of the same, resulting in an agreement. So agreement equals to valid offer plus valid acceptance, or lawful offer and lawful acceptance. The second essential condition is the intention of the parties involved. There must be an intention among the parties involved to create legal relationships or legal obligations out of the agreement. There are a number of case laws that can be cited in order to explain this particular point, the most important being the case of Balfour versus Balfour 1919. Now, in case you want any of these points to be explained in detail, you can put that as a message and I can take up the particular essential element in detail or in depth along with the case laws. This being a shorter presentation, it will not be possible for me to discuss the case laws or any of the elements in detail. Agreements of social domestic nature that are not intended to be performed with any or to be attached with any kind of legal obligations will not give rise to contract. The third requirement is lawful consideration, which means something in return. It means that both the parties to the contract must receive something in return. If one party is merely giving the goods and not getting anything in return, then that would translate as a gift or a donation and will not lead to a valid contract. The fourth essential element is the capacity of parties involved. Now, the parties to the contract must be major to begin with, that is, they should be over the age of 18 years, of sound mind, in the sense they should not be suffering from any kind of mental illnesses, that could be Alzheimer's, dementia, or any disease that renders them incapable of taking a logical and rational decision. And C, they must not be qualified from contracting under the law to which they are subject. So that could include alien LMEs or undischarged insolvents. Moving on to the next slide, which talks about free consent. The consent of the parties to the contract must be free, which means that they should have agreed upon the contract in the absence of any of these conditions that are mentioned here. Or as you can see here, there is absence of free consent if the agreement is induced by, say, coercion, that is force, which could be physical, which could be mental, undue influence, that is wherein one party is in a position to unduly influence the opinion, or you can say the decision making of the other party, and that is implied under certain relationships like a doctor and his patient, a lawyer and his client. The third is misrepresentation. Again, misrepresentation means representing a fact in a wrong manner or concealing certain facts from the contract. Fraud again implies that there is lack of free consent. And lastly, mistake. So, free consent means that the parties must have agreed upon the same thing in the same sense, and there should be absence of any of these elements while contracting. The sixth essential element is lawful object as per section 23. The object of the contract must be legal, it must be lawful. So, a contract to commit a robbery and share the proceedings among themselves would be unlawful, would not result in a contract, for the simple reason that the object of the contract is illegal or unlawful. The seventh essential condition says writing and registration. However, a contract may be oral and it is absolutely valid. However, it might be difficult to prove the same in a court of law, that is the terms and conditions, if they are not written. It is not mandatory that every contract must be in written. However, there are certain cases, certain special types of agreements that must be written in order to constitute a contract, like an agreement for sale of immovable property. So if you are planning to purchase a flat or a land, the contract must be written, it must be registered and stamped. For the other contracts, they are considered to be valid even though they may not be written. The last 3 points: certainty. Agreements the meaning of which is not certain or capable of being made certain are void. So the meaning or the word should be very, very clear. Any ambiguity with respect to the meaning of the agreement will make it void, will not result in a valid contract. So a man enters into an agreement to purchase 10 liters of oil. Herein, unless and until it is clarified what type of oil it is, the agreement will not be valid. The ninth point is possibility of performance. So that you can see by way of illustration, A agrees with B to discover treasure by magic, and this is not a valid contract due to the fact that it is impossible to perform such an agreement. Lastly, there are certain types of agreements that are expressly declared to be void, and they are mentioned or contained under sections 24 to 30. These include agreements in restraint of marriage, agreements in restraint of trade, agreements in restraint of legal proceeding, agreements by way of wager, etc. So this was a quick go through or through the essentials of a valid contract, and what we conclude out of this is that all contracts are agreements, but all agreements are not contracts. In case you want me to explain any of the essential elements in detail along with examples and precedents, kindly mention so on my channel and I will take it up in the next presentation. Thank you everyone. Have a good day.